Bom dia a todos e a todas. É um prazer recebê-los aqui hoje para mais um evento organizado pelo Compete, o núcleo que trata de concorrência, políticas públicas, inovação e tecnologia aqui na escola. Eu vou começar em português para ler um disclaimer que a gente lê em todos os nossos eventos aqui. Mas, basicamente, que as manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participam dos eventos e transmissões online, apesar de a gente não estar transmitindo, a gente está gravando, representam exclusivamente as opiniões dos seus autores e não necessariamente a posição institucional da Fundação Getúlio Vargas. Reiteramos também que todos aqui presentes concordaram em participar desse evento de forma espontânea e, com isso, autorizam o uso de sua imagem para sua transmissão, que ficará disponível posteriormente nos canais oficiais da FGV. E do Ibrac, que é nosso parceiro nesse evento. Now, I'll shift to English so that we can all speak the same language here as Professor Richard Whish. And good morning to you all. Good morning, Professor Whish. It's a great honor to have you here with us. Since last year, we've been organizing a series of events on competition law, many of them dealing with the urgent issue of digital markets and the discussions that these brings both in Brazil, in Europe, in the US, and globally, actually. So it's a great honor to have here with us today Professor Whish, who is a professor emeritus at King's College London. In 2014, he was nominated honorary Queen's Counsel honoris causa. And he's been the director of the Office of Fair Trading and the director of Singaporean Energy Markets Authority in 2005, between 2005 and 2011. And he's certainly one of the foremost authorities in European competition law and UK competition law. So we couldn't be in better company today to have an overview of discussions about investigations on abuse of dominance and new tools to deal with digital markets. So Richard does not need any introduction, but I tried to do a very brief one, nevertheless, and I'd like to welcome you all to this event. Before we move forward and we listen to Professor Whish, I'd like to share the floor with Bruno Drago. This is an event that we're organizing together with Ibrac. Ibrac is the antitrust bar in Brazil, so all attorneys, economists that deal with antitrust and competition issues in Brazil are associated somehow with Ibrac. Bruno is the president of Ibrac, and we've been organizing a series of events between FGV and Ibrac, and it's always a very good dialogue between the academia and the practitioners so that we can reflect and we can discuss the matters of competition law. So thank you very much. And I also acknowledge here Leonor Cordovil, my partner in Compete, the research nucleus, professor at this school, and also co-organizer of this event here. So Bruno and Leonor, please, I'd love to hear a few words from you.
Thank you, Caio. Good morning, everyone. So thanks again for opening FGV for this event. I think Ibrac, for all the last years, have been trying to get closer to the academy. And I think we've been very successful within the last years. An example of this, I think, will be an event that we're going to have together with several universities in May. I think it's 15th of May to 19th of May, which is going to be the first time we're launching the week of competition. And the idea is to have different events in the morning, all 5 days in the morning. We're going to have a local university in São Paulo, together with a university outside of São Paulo, hosting the event to discuss competition and to actually present to the universities a work that is being developed by the committee of Ibrac, which sort of tries to show the importance of having competition as a subject on university. So I think it's going to be the first year we're going to launch that. Hopefully we're going to have for the next years. and trying to get the academy and the practitioners together every time more. So Professor Whish is, I think last time you were here, we were talking this morning, I think it was 4 years ago. From time to time, he comes back to Brazil and he tries to show us what has been going on in Europe, all the developments, so we can reflect and see what we can get from that we can apply here in Brazil as well. Or we shouldn't apply in Brazil. So I think it's an honor to have him. I think it's the 4th time you come back to Brazil. Thanks again for being here. And he's gonna hold a course. It's gonna be tonight, tomorrow night, and Wednesday night. So 3 days, 3 hours. He's gonna pass through abuse of dominance, cartel, and all those news that the European Commission has brought last year and this year. So whoever has interest in participating, please contact Ibrac. We still have places for this event. Thanks again. And Leonor.
Hello. Hi, good morning, everyone. Just a few words. First of all, thank you very much, Professor. It's an honor to have you here in our school. When we learn and start learning antitrust in our lives, I think the first thing that the first word that we learn is abuse of dominance, maybe the expression. The second one is cartel, and the third one is Professor Whish. So it's an honor to have you here, and I would like to also to thank you, my students, for being here, and also our group of women on antitrust. We have some of us here today, and also in the presence of our VP, Vice Vice President Silvia Almeida. It's an honor to have you here, Silvia, as well. And thank you very much, Bruno, and obviously Caio, for organizing this and bringing Professor again to us. In just a few words, after here, just a few message here, but after here we'll have a group of Ibrac that is going, that's Ricardo's Mota's group. We have a digital platform meeting regarding this group, and after we have this meeting here, so be the ones that want to be here, please stay with us, and including the ones that are not part of the group, we are here, so please join us if you want to work and learn more with our group and have more discussions on this area. Thank you.
Thank you, Leonor. Thank you, Bruno. And just one last register that I'd like to make, that Professor Whish was really kind to open King's College for my visit in 2018 and 2019. So it's a pleasure after the pandemic. So this was before the pandemic. The road changes throughout the pandemic, and it's a pleasure to have you back to Brazil after the pandemic. So thank you very much for being here with us. So without further ado, please, Richard, take the floor. It will be a pleasure to listen to you on these matters.
Well, thank you very much, Caio, Leonor, Bruno. It's wonderful to be here, to be back in Brazil. As you say, this is my 4th visit, and I was just reflecting. Oh, I beg your pardon. Yeah, because you're recording. I was just reflecting on the fact. Is that okay? Yep. Reflecting on the fact, 2019. How much did we all know about digital platforms and competition law in 2019? It was an issue that was emerging, but it was very much on the horizon. And I think anybody in the antitrust community has learned a huge amount in the last 4 years, and there's a lot more learning to go. Now, in terms of this audience here today, my understanding is that some of you are students and some of you may be relatively new to competition law studies. Others, I know, are much more experienced. So it's always very difficult when I put a presentation together like this to know exactly where to pitch it. But I think, given that I'm in an academic institution now, I hope the non-students here will understand if I say some fairly basic things just to introduce the subject. But what I'm really going to concentrate on in the title is is Article 102 fit for purpose? So what I'm going to do with these slides, and by the way, Kaio, I'm absolutely happy for you to make these slides available to anyone who is interested. The early slides just set out the problems associated with digital platforms, homing in on, if you like, the economic characteristics of platform markets that make them complicated from an antitrust point of view. But what I'm going to concentrate on is, firstly, looking at some of the recent EU cases, just so we know the kind of theories of harm that the European Commission and other competition authorities in Europe have looked at. But then at the heart of this presentation is about 5, maybe 6 slides about why is it that Article 102 doesn't seem to provide a complete answer to the problems of our time. I've got a few slides then on the Digital Markets Act, which of course is now in force in the EU. I am aware Bruno sent me your bill, so I'm aware of what kind of things are contemplated here. But that's what I'm going to do. I will limit myself to about 40 minutes because when I come to an event like this, the discussion, the questions, the comments are much more fun, I think, than me listening to my own voice. I've been doing that for 40 years and I've got bored of it by now. So, digital platforms and competition law. These early slides state what is by now for all of us fairly obvious. This is simply setting the scene. Of course, digital platforms have done amazing things. All of us consumers, billions of consumers around the world, have benefited from the emergence of search tools and social media groups and so on and so forth. And maybe there is a problem with some of these platforms, but we mustn't allow competition law ever to get in the way of innovation. That is absolutely obvious. So if we're going to apply competition law, if we're going to regulate, as with the DMA in Europe, we've got to set the regulation in such a way that it doesn't disincentivize people from continuing to innovate and producing these wonderful new tools that everyone benefits from. Obviously now we're into the new chat box era. Very interesting things are going to happen there. Now, we know that over a period of time, really in a sense from about 2019, by then it had become clear that governments worldwide, competition authorities worldwide, were beginning to have concern about the platforms. Acronym can be GAFAM. They keep changing their names, so my latest one is MAMA. Probably in a few years there'll be a new acronym. But lots of issues that people were debating, including spreading fake news, online harm, facilitating terrorism, etc. And we've got to remind ourselves that we are here as humble competition lawyers. Competition law can't deal with all of those things. We've got to focus for our purposes as a competition law community on where antitrust, or if not antitrust, economic regulation might provide solutions to some of the problems. And so, I beg your pardon, I went on. What we have to think about is, what is it about digital platform markets that seems to give rise to particular concerns as opposed to the beer market or the fast-moving consumer goods market or the heavy steel tubes markets? What is it about these markets that give rise to concerns? And I think this slide sums up most of the particular features that we are talking here about: two-sided, multi-sided markets, which is complex. Nothing new about two-sided and multi-sided markets. You can go back 50 years and identify them. But these are paradigmatic examples of two-sided, multi-sided markets. Clearly, there is the big data issue associated with these. And this isn't just big data. This is monumentally vast data and in some circumstances, data which the platforms themselves are able to acquire that other participants in the market cannot. Obviously, there are extreme economies of scale and scope. Barriers to entry and expansion for somebody wanting to devise the new ecosystem to challenge Android and iOS are enormous. The network effects are very powerful. Particular problem, and I'll come to this when I get into the particular problems with competition law, is the tendency of these markets to tip, so that a market can tip in favor of Android or tip in favor of Facebook or whatever. And a market, once it has tipped, how do you restore conditions of competition to a market once it has tipped? If everyone is using a particular platform, you might tell them it would be better if they used a different platform, but they don't. So what do you do about that? So I think one of the great difficulties here is the whole question of A, preventing the tipping in the first place, and B, devising a remedy for markets that have tipped. Those are characteristics of these markets, and you can look at something like digital advertising, and it's clear that Google and Facebook, they just simply do have, often called casually now, a duopoly. It just seems to be a fact of the matter that these do have jointly huge market power. And so there are issues here. And over a period of time, all these various reports were published at the beginning of the teens, as it were, and then these reports came out 2015, 16, 17. Many of you will be very familiar with them. Those are, I would say, some of the most influential reports, but I say many others. I've been terribly impressed, actually, by the number of competition authorities around the world, in Mexico or Singapore or Australia, that have made extremely valuable contributions to this whole debate around platforms. And anyone needing to get up to date with what's going on, I think, needs to begin by drawing up a list, as it were, of all the different reports that are out there already. There's no point in research work in reinventing the wheel when very, very good work has been done globally by lots of different institutions. And so, focusing really in now on competition law and the platforms, it is this gatekeeper role. I use the word because that's the word we now use in the EU. I say we in the EU. I still to this day do not believe in Brexit. I mentally have not Brexited. I'm still a citizen of the EU, but I can't find anyone to give me a passport. Anyway, leaving that personal trauma to one side, the EU has got its DMA, and it focuses on this idea of the gatekeeper. And when I come on to the defects of competition law, it's going to be what are those defects? And what the DMA effectively does is to say, let's designate certain people as gatekeepers. And that means that we don't have to define their market. We don't have to establish their market power, because by being a gatekeeper, that automatically attracts obligations, which are much easier to enforce than going through the Article 102 process. Now, it is this gatekeeper effect that creates the difficulty in many of these cases. And then the Commission started looking at a series of cases. And what I'm going to do, just in 5-6 minutes, is to give you some of the star cases, because it shows that the Commission has been very active in this space. But the cases, I think, also show up some of the difficulties in the traditional application of Article 102. There's a separate issue, the final bullet point there, which is the so-called killer acquisition debate. I'm sure you have debated that extensively here in Brazil. This being the idea that you've got a platform such as Google or Facebook, which has become very powerful, and then there's all the clever young startups out there, and who knows which clever young startup might one day be the new arrival that topples Google or Facebook from the perch, because we do believe in competition and we do believe in entry and so on and so forth. But of course, it might be that those platforms systematically buy up every possible new threat that enters the market, thereby killing potential competition. So that's a kind of a subject of this whole digital platform agenda. Now, just a few slides. How many have I got? About 5 or so. A few slides on the cases that the Commission has been doing over the years. And there's a tendency to sort of dive straight in with Google Shopping and Google Android and Google AdSense. But let's not forget, back nearly 20 years now, the Commission's Microsoft decision of 2004. Because in many ways that helped to establish the infrastructure of Article 102 jurisprudence, which is still applied to this day. So the old Microsoft case was about a situation where Microsoft had devised its Windows operating system, and it was accused of doing two different things. One is of including in the Windows operating system a media player. Query, was that a tie-in transaction? Now, one can debate that for an hour, but suffice it, probably when you were a student, I would imagine, with me at King's. And it was established in that case by the Commission, upheld by the General Court, that the inclusion of the media player in the Windows operating system was a tie-in transaction. Controversial, but it was upheld on appeal, and so that becomes one of our abuses that can be applied in the modern era of the digital platforms. And of course, if you look at Google Android, what was the essence of the complaint in Google Android? That the Play Store, the search engine and the browser had been tied. And okay, if we're looking around for a precedent, because as lawyers we love precedents, don't we? Well, there's a very clear precedent for Google Android, Microsoft. So the Commission's work all those years ago came in very usefully in the modern era. Also in Microsoft, there was the refusal by Microsoft to make interoperability information, interface information, available to producers of other software for hardware that wanted to interoperate with laptops and desktops working on Windows. So could the refusal to supply data, because we are talking here data, information, can the refusal to supply information be an abuse of a dominant position? Commission said yes, upheld by the General Court. So there we have a precedent from 2004, the judgment was 2007, that interoperability information is something that can be shared forcefully through the use of competition law. So Microsoft, all those years ago, actually has turned out to be very relevant in our current times. Google Shopping, we all know Google Shopping, so you've got the Google search engine, we search with Google, you want to buy something, and what happens on page 1 of the search results, there is Google, there is Google Shopping at the top of the page, very prominently displayed. There are other shopping tools that I, Richard Whish, might be able to use, I might actually find better than Google Shopping, but they're all relegated to page 4 of the search results. Does anyone ever look at page 4 of the search results? And the Commission can test that empirically, and they find in the history of mankind only one person ever reached page 4, and he was very lonely, living on his own in the top of Finland, not really much of a group to base a policy on. So that's held to be an abuse of a dominant position. But then, of course, the interesting question becomes, well, what kind of abuse is that? Is there a precedent for precisely that behaviour? I'll come back to that in a moment. Google Android, I referred to just now, that's the Yes, you can have access to the Play Store if you pre-install the search engine and the browser. Commission says that that's an abuse, upheld by the General Court, now on appeal to the Court of Justice. Google AdSense, more traditional kind of abuse as I see it, essentially whether there were exclusivity agreements, and if so, were those exclusivity agreements abusive? Commission said yes. Now on appeal to the General Court. I think the judgment there is due in about September of this year. 2 cases against Amazon. Firstly, you've got anything up to 1 million merchants selling their stuff through Amazon Marketplace. Amazon, through its algorithms, can acquire, can make use of all the data of all of those merchants and their sales through Marketplace. What are they selling? Where are they selling? What demographic group are they selling to? At what price? And then over here, Amazon itself is a competitor of those merchants, so can use that data to inform its own choices qua retailer. Well, is that an abuse of a dominant position? Separately, I'm buying something on Amazon and I'm near to making my choice, and the Amazon buy box appears, and then through the buy box I'm nudged towards Amazon products, or alternatively I'm nudged towards making use of Amazon Prime and its logistics, because if I buy from X, I'm told that the item in question will arrive in 10 days from now, whereas if I use Amazon Prime and go out to my front doorstep, I'll find it's already there, because Amazon's so clever that it predicted what I wanted. Well, that's a slight exaggeration, but I mean, you're very much being steered towards the Amazon products. Interestingly, just before Christmas, the Amazon gave commitments to the European Commission to abandon those practices. So that was an interesting example of intervention by the Commission that didn't necessitate the adoption of infringement decisions, because Amazon agreed to change their behaviour anyway. Then there's a couple of cases against Apple. And there's the whole controversy around the Apple App Store. I know that's being looked at here, it's being looked at in the UK, it's being looked at in Australia. Query, when I want to access an app through my iPhone, am I put into a position where A, I've got to download the app through the Apple App Store, B, I've got to pay for it through the Apple in-app payment system, C, Apple ensures that the app developer doesn't steer me to some alternative way of acquiring the app. Are these abusive behaviours? Note there that the Commission has recently, in February, narrowed its investigation of Apple down to the anti-steering provisions. That's quite interesting. We could debate why the Commission may have done that. And there's the Apple Pay case. Is Apple preventing other payment systems from being loaded into this phone for when I go to purchase something from a merchant? We've also got the case in Germany against Facebook. The UK has taken action against Google in relation to its so-called privacy sandbox. The CMA in the United Kingdom has done a number of very interesting market studies of all sorts of issues: comparison tools, advertising markets, algorithms, ecosystems. I'll come back to ecosystems in a moment. Mobile browsers, and also the CMA. This is a Brexit point I'm making now. Historically, the big cases against GAFA or MAMA have been done by the Commission in Brussels. But now that the UK has Brexited, the CMA in the UK is now conducting its own cases against each of Google, Apple, Facebook and Amazon. Pre-Brexit, they would not have done that. Post-Brexit, they're very much involved in these very difficult cases. It makes the CMA, frankly, it makes the CMA a much more interesting place to work today than it would have been in the pre-Exit era. There have to be some benefits of Brexit, I suppose. And of course, so I'll go back. And of course, there are loads of investigations of the GAFAM companies worldwide, including here. Isn't it strange or interesting to think that in the US, you have this sense that the US is behind everybody else nowadays? But also, I think it's a very interesting idea, the sense in the US that historically they were critical of the European Commission for being too interventionist and too pro-interference. And I think a lot of people in the US are now thinking maybe the European Commission had a point and maybe we need to sharpen up our enforcement activity. It's a very interesting dynamic to watch at the moment, but maybe that's a manifestation of the Biden era as opposed to previous eras. That slide just simply refers to that killer acquisition point that I made earlier. Now, this is what I really want to concentrate on, the next few slides, because the purpose of the talk was to ask, is Article 102 fit for purpose when it comes to this whole phenomenon of the platforms? And of course, I think you said the first expression we come across is abuse of dominance, and we're taught abuse of dominance. And so how does it go? You define a market, you determine the market power, you then look for the abuse, and then you adopt the infringement decision. And that is conventionally how you do an abuse of dominance case. But does this really work in relation to the kind of markets that we're talking about? And I think there are lots of problems. Of course, it can be done. We've seen those cases, but there are lots of problems. And the first one is just this question of market definition. How do you define markets? And there are plenty of people in the business of antitrust. Forget digital platforms. There are plenty of people who say that far too much emphasis is placed on market definition in any kind of case, forgetting digital platforms, because market definition, it is, as I say, it's an artificial construct. It's something that's been created as a result of legal systems that use this term dominance. So the Court of Justice in Luxembourg says in 1973, if you're going to accuse somebody of abuse of dominance, well, you've got to start by establishing dominance. You can only establish dominance by identifying a relevant market. And so it becomes like a series of dominoes: market definition, dominance, abuse. But is that really that sensible? Because, let's not fool ourselves. You can never define a market with absolute precision. However you define the market, whether it's that big or that big, there's always going to be someone outside that market that could enter it. In other words, however you define the market, we're really trying to find out how many constraints are there on a person in a market, which is really another way of saying how much market power do they have. So we shouldn't attach too much significance to the market definition. We in the UK, incidentally, have systematically over many years downgraded the relevance of market definition, whereas in the EU, still to this day, there is a kind of a commitment to market definition as a part of the process. And I imagine you all know that the Commission is on the point now of issuing a new notice on market definition. I don't know how many of you have looked at it, but it's now very extensive and I think a very interesting and well-researched document. So, market definition has its problem. And how do you apply a SNP test, a small but significant non-transitory increase in price? How can you apply that in any meaningful way to these digital platform markets, where often, apart from anything, we're not talking about markets that already exist. We're trying to anticipate a future in which entirely new products that we can barely get our heads around are going to come into being. what is this whole chat box world about? Where are we going with artificial intelligence? What is the metaverse? We know that these are big issues and they have to be dealt with, but can they be dealt with by defining a market? When frankly, with the best will in the world, we don't even know what this thing is, or rather, these things are. So, and if we don't even know what they are, how can we hypothesize a small but significant increase in price? I mean, hello? It doesn't really seem to make terribly much sense. And then just to add to the complexity, we are talking about two-sided and multi-sided markets here. Well, how does price get factored into two-sided markets where I, as a user of Google search or Facebook, don't pay anything? There is no price for me. But then, of course, there is a price for advertisers on the other side of the market. So what do? Do you add the two prices, naught plus that price together, and divide it by 2? I mean, how do you apply a snip test in these very complicated circumstances? Well, maybe instead of applying a snip test, you should ask yourself what would happen in the event of Facebook degrading the standards of privacy afforded to users of Facebook. In other words, should we hypothesize a small but significant non-transitory decrease in quality? A very easily pronounced acronym, a SNUDICA. It's not quite as easy as SNP, is it? But, do we apply a SNUDICA test? But then what is small but significant? A 10% decrease in quality? I mean, how do you assess such a thing? So we've got another problem there. And also, if a legal system places this great emphasis on market definition, it is utterly inevitable that the market definition is going to be appealed. And so in Google Android, Google appeals to the General Court that the Commission got the market definition wrong, but then the appeal takes 2 to 3 years, and of course armies of economists are going to come in on both sides, or 3 sides maybe if there's an intervener, with their formulations of how the market should have been defined, and in a curious kind of way they might all be right, because there is no precise market definition. So inevitably you're going to have an appeal process which is going to take donkey's years to be exhausted. Because of time, I won't go into the market definition in Google Android. Suffice it to say, in a case like Google Android, a question is, should the Commission be looking at a Play Store market and a browser market and a search market? Or should it have been looking much more panoramically as the competition that exists between inhabitants of the Google Android ecosystem and the Apple iOS ecosystem? Because you might get very different results if you take an ecosystem approach as opposed to the old-fashioned narrow approach. Suffice it to say, the General Court says, we understand the idea of an ecosystem market definition approach. We just don't think empirically on the facts of this case that it was an appropriate case for the application of ecosystem thinking. And that case, incidentally, has now filtered through into the Commission's draft notice on market definition, where the Commission does talk about possibly taking an ecosystem approach rather than the, if you like, traditional approach. To sum up that slide, what I would say is, of course, once you get to the DMA and you designate people as gatekeepers, forget market definition. Well, at the very least, that makes enforcement an awful lot easier, because all of those hugely difficult things are bypassed altogether. And then, in a way, I can just repeat all the same stuff again when it comes to market power. Market definition was never an end in itself. It's a means to an end. It's like trying to climb Mount Everest, and you first get to base camp 1, and then you get to base camp 2, and then you assault the summit. Well, it's the same thing here. Firstly, let's get to the market definition, then let's get to the market power, then let's look for the abuse. So we've had a long analysis of market definition. Now we're going to do the market power bit of it. Well, how do you assess market power when the market is evolving incredibly quickly? We are told again and again and again, quite rightly, to recognize that where markets are dynamic rather than static, rapidly changing, market shares really aren't that meaningful, because somebody might, for a period of time, have 100% of a market. But then it may well be that there's some brilliant new product about to enter the market that topples the incumbent from its perch. You know, IBM was once the monopolist, Microsoft was once the monopolist, and then you find that these people have eventually lost some of their battles, at least, to somebody else. So you've got that problem. And anyway, when we're talking about the platforms, certain platforms, isn't the concern that somebody in the position of Google, for example, ends up in such a powerful position that it can very easily reach out and annex a whole cluster of neighbouring markets, not even necessarily vertically related markets, but you're in such a position of power that it's very easy to enter the shopping market or the mapping market or the recruitment market or whatever. And so really, the question of whether you're dominant in a market is not the point. The point is you've positioned yourself within an ecosystem where you're so powerful that you can envelop, you can leverage, you can, whatever vocabulary you want to use, reach out and dominate other markets. Hence the idea of the gatekeeper. Alternative variants of this would be in the UK, if and when we get our draft legislation, which the government has recently said is due by the end of this month, we are not going to follow the EU with the idea of gatekeepers. We are going to try to identify firms that have strategic market status. That is to say, here we've got a digital platform, to use that term very loosely. Some firms have strategic market status there, and that will lead to some kind of ex-ante regulation. Germany, of course, has already legislated this idea of firms that of paramount significance across a number of markets. But these are all variations on the same theme. It's departing from traditional 102 analysis to identify certain firms where we have a problem. And of course, again, therefore, the DMA, the German, the proposed UK solutions obviate the need to identify market power. Then the next question is, let's say we find that X is dominant. Now we're assaulting this summit of Everest. Now we're looking for the abuse. Well, especially lawyers, courts, legal advisors, they love certainty. I find lawyers particularly like certainty with flexibility. It's an interesting idea. But people like certainty, and so you get Google Shopping, and the question is, well, we know what they're doing. We know Google Shopping's on page 1, and the other shopping tools are on page 4. But is that an abuse? Let's get a textbook on abuse of dominance and find the precedent that shows that that's an abuse. But of course, probably you're going to find that there is no precise precedent. And so you get into this whole sort of almost metaphysical question of how do you know when something is an abuse? If there isn't an exact precedent, how do you know it's an abuse? One judge of the Court of Justice once told me, I know when there's an abuse because I can smell it. But it's not really a good way to give legal advice, although I think he was correct. But anyway, leaving it to one side. How do we know that Google Shopping was a case of an abuse? And it is very interesting because the appeal of Google to the Court of Justice is, and this has been tried again and again and again, what they say is, look, the Commission and the General Court say that by putting Google Shopping on page 1 and relegating everything else to page 4, this is said to be an abuse. But if that's correct, they have got to have accused us of the correct abuse. And what they're really saying is that the other shopping tools had a right to appear on page 1. But if they're saying that the other shopping tools had a right to appear on page 1, they must be saying that page 1 is an essential facility, and that therefore there's an abuse if you refuse to give access to the essential facility. But in EU law, that means you have to apply the very high standards of Oscar Bronner and media print. And it's the first ground of appeal of Google to the Court of Justice that this should have been run as an essential facilities case. And it's a good argument. I profoundly disagree with it, but it's a good argument. And we might discuss this afterwards because there's a lot to say about it. And the Court of Justice has got to address that. And it's either going to say, yes, this is an essential facilities case, in which case, Commission, you didn't do it correctly, or it's going to say it's not an essential facilities case, in which case you've got to explain why it is not. It's intellectually interesting, it's academically interesting, and my God, it's important to this case. And I see in this morning's Financial Times, a very clever D.Phil student at Oxford University has written a letter on that very, very issue. I wish he was here now to join in the debate. Literally today, the first letter on the FT page is about whether these cases should be run as essential facilities cases. And he says emphatically no. So, of course, effectively, what Google Shopping decides is that self-preferencing is an abuse. But then, is that right? Because lots of people self-preference all the time. So, therefore, why is it that in Google Shopping the self-preferencing was an abuse? Now, we can debate that for years, and that's my last bullet point. But it is being debated for years because the decision was 2019. It's been to the General Court, and it's now in the Court of Justice. Is this not, if you like, a defect of Article 102? Which leads to exactly the next slide. Is competition law too slow? Is this not really a problem? Especially when you bear in mind what I said at the start, that these markets tip. And having tipped, how do you untip a market? You can't tell people don't use Facebook or don't search with Google search. For heaven's sake, people must do what they think is in their best interest to do. So I think this tipping thing is a problem, and even straightforward abuse of dominance cases with the investigation and the 2 appeals that we have, General Court and Court of Justice. This is 7-8 years. Typically, well, how useful is that in the world in which we're living? Should competition authorities use interim measures to sort of stop everything in its track pending the next 7 years of investigation? Then that means 7 years of people not being able to develop and innovate and whatever. I mean, interim measures is a tricky issue. And so, slowness is obviously a problem. And I have to say, a little bit cynically, I've no doubt, lawyers and economists know many, many ways, if they're acting for defendants, to spin out the process for 7 years, because that's 7 years of legal and economic consultancy fees. That's another yacht somewhere. So, the lawyers and the economists are invested in these cases in a very, very big way. What about remedies? And different points here. Firstly, fines. Okay, Google's been fined 8 billion euros plus by the Commission in a few years. 8 billion euros, wow, what a lot of money that is. If somebody wants to give me 8 billion euros, I would happily accept it. But what is 8 billion euros to Google? I mean, frankly, it is nothing. And I don't think fines can ever be a deterrent in the world in which we're discussing here. Damages could be significant, conceivably. And in the United Kingdom, we now have class actions, including on an opt-out basis. And there are gigantic class actions being brought against all of the GAFAM companies. Well, let's see where that leads to. I can see how today, in antitrust generally, not just in this area, for certain undertakings, I think the risk of damages claims is more significant than the risk of the fine that one might have to pay. But it's very difficult to see where the deterrent effect comes in. And then what about, more specifically, what about the remedies that you impose? Quite apart from fining, awarding damages, what is the answer to Google shopping? It's one thing to say that there's an abuse. It's another totally different thing to say, well, what is the right remedy for that abuse? How do we deal with the ranking of shopping tools after a search by an individual? Remedy setting can be incredibly difficult. And simply saying, well, you know, as politicians will do, you've got to break these platforms up. I mean, that just makes no sense, because if you break the platform up, it goes back to my first slide, you've got to remember how good these platforms are for billions of people. And you don't want to proverbially throw the baby out with the bathwater. So there's a great difficulty, I think, in knowing what the right answer is. Now, I'm not going to go through this because I dare say you're familiar with it. But this is the case for having a Digital Markets Act, where you just identify certain people as gatekeepers, and then you list certain things that they must or must not do. Or ditto, we in the UK will say certain firms have strategic market status, and then they must or must not do this. So that's the case for ex ante regulation. And apart from anything, it takes out the whole problem of market definition. It takes out the whole problem of market power. It takes out the whole problem of, is there a legal precedent that matches the theory of harm that is being articulated. One other thing it does, incidentally, is to remove from the analysis any argument of the gatekeeper that what it is doing is economically efficient. You know, you think of 1011, 1013, economic justifications for the restriction of competition. As the DMA was going through the legislative process, lots of people were saying, well, okay, so we can't self-preference, but what if we've got an efficiency justification? And the Commission, Parliament, Council were adamant, no, we're not having that stuff. So the efficiency defence, if you like, is totally eliminated under the DMA. So the idea at the end of that is that you end up with a much quicker, easier law to enforce. Will it work? Can I come back in 5 years? So basically, those are a few slides on the DMA, and I conclude by saying thank you for your attention. Thank you.
Thank you very much, Professor Whish. This was a very thoughtful and provoking presentation. I think it's extremely interesting for us to hear the state of the debate in the UK, in Europe, and actually worldwide, as you put it. I think Professor Whish was kind enough to be open for questions, so let's open the floor for questions. Bruno, Leonor, I think we can also mix with some of our own comments and questions as well here on the table, but I'd like to open the floor for questions. If anybody wants to make a question in Portuguese, also feel free. We can translate here the question as well. Any questions to start with? Please, Ricardo. I think we should use a microphone because of the
recording.
Yeah, because of the recording.
But that's fine. So first of all, thank you, Professor, for this great presentation. I think one of the questions that when we study these sort of things, it comes up is that we understand that there's a lot of problems. There are a lot of problems going on with digital platforms. But when we go to the DMA, we have a per se system, which is basically that you disregard market definition, you disregard efficiencies, and in most of these cases, even in the Apple case, Amazon case, Google case, in most of jurisdictions, you have very close calls on the decisions of those cases. So, for example, you have a very disagreement between commissioners in the United States. You have disagreement among commissioners in the European Commission, even reports inside these commissions. So, aren't we going to a very like a system where we can do everything and investigations take years to have decision, to a system where basically we are going to a very narrow possibility for companies to defend themselves? And if you go back to the 80s, 70s, most of the evolution and innovation that was introduced in the market, they came from some of these conducts that they are listed in the Articles 5 and 6 of the DMA. So shouldn't we go, for example, for changes in the system where we could, for example, switch the burden of proof for these companies and go one step, smaller steps between these systems, so we could figure out what would happen with the investigations before going to a very different position?
Well, okay, I mean, a perfectly reasonable suggestion. I mean, to my mind, I think it's a question of having to decide how big, how acute do we think the problem is. In terms of competition law generally, as it applies to the economy generally, I don't like, in principle, I don't like ex ante regulation. I think if it can be avoided, it is better to avoid it. Ex ante regulation can become very rigid, sclerotic. I think once you've put regulation in place, it's one of those terrible things. You put a regulation in place, but it never gets revoked. And so you just, it's like sort of the barnacles that attach to the hull of a ship. You just get more and more barnacles and more regulation. So temperamentally, I'm opposed to regulation. However, it's a question of how serious do you think the problem really is. And I mean, it is interesting if you look at the 2010s, say, these issues that we're talking about, people started to think about them early in the teens. And I remember that period, and predominantly the feeling was these, you know, the products that are emerging from this are so fantastic. They're conferring so many benefits on so many people in society, including businesses as well as consumers. Let's not interfere too much. Because you do want the incentive to innovate and so on and so forth. But I think that something changed in the middle of that decade. And that's when all those reports, the Kramer report and the Furman report came on, because there was that sense of, oh my God, have we been a bit negligent here? Were we asleep at the driving wheel? And, you know, Facebook acquired Instagram and Facebook acquired WhatsApp, and they weren't looked at. And then, oh, what have we now got? And I think that, in a way, of my slides there was the slide about the two-sided market, the tipping effect, the economies of scale, the economies of scope. All of those things are, I think, very specific to the markets that we're talking about. And the fear is that just a few very big players will end up, as it were, dominating the world. Now, some people would say, I'm a total believer in markets. I'm a total believer in auto-correction. And once upon a time it was IBM, and then it was Microsoft, and then it was Google, and then it's going to be somebody else. So let's just let the market work out. And you might believe that, and I'm not saying it's unreasonable for people to believe that. It's not what I believe, because I think the problem is a very acute one. And so you can then get into the false positive, false negative dilemma. Is it better to intervene wrongly, or is it better to do the opposite? And I think with these markets that there is a real risk. Reversing the burden of proof, I just don't see that that gets you anywhere whatsoever. Because if you reverse I mean, that's just a legal thing, isn't it? But if you're reversing the burden of proof, it still means that someone's going to present the market definition as being this, and somebody's going to present it as being that. And then, okay, did I start 1-0 up or 1-0 down, or do away goals count double? That's all that the the burden of proof is saying. It doesn't eliminate the problem. To me, I mean, it's very nice to be asked to do this, actually, because having decided that I think there are arguments on fitness for purpose, it caused me to reflect on those middle slides in this presentation. And I think that each and every one of them is valid, actually. The market definition problem, the market power problem, the theories of harm problem, the remedy problem. I suppose a different thing I would say, though, is that if you are going to have ex-ante regulation, I think it has to be smart regulation. It should not be regulation for the sake of it. And I've always believed with any system of regulation, it should be possible within the system itself to remove regulation as well as to add to it. And I would be worried if just the list of no's just gets longer and longer and longer. I would like it to be possible to get rid of no's. And the DMA does provide for that. In the UK, with our strategic market status idea, I haven't seen the draft legislation, but I know what the relevant people have in mind, which is to say that certain firms will be designated as having strategic market status. But then a code of practice will be drafted according to the particular business model of that platform. Because we have to remind ourselves, not all platforms do the same thing. What a social media platform does is utterly different from a platform that is about selling things like Amazon. So you have a specific, a bespoke code of conduct per firm with strategic market status. And then I think the legislation will say what goes into that code of practice, into any ex-ante regulation, will be specifically required to be pro-competition. That is to say, you don't just regulate for the sake of having a list of do's and don'ts. You regulate because you think this firm with SMS is impeding entry by suppressing the dissemination of data, for example. And so you actually design your regulatory system to be pro-competition. But what you were saying, to my mind, doesn't address the, if you like, the enormity of the problem that we have here.
Okay,
I would also say, incidentally, just one last comment, which is that when it comes to the designated gatekeepers, there aren't going to be lots and lots and lots and lots of designated gatekeepers. I mean, that there will be hundreds, thousands of platforms doing things that won't be touched by the DMA at all. They will still be subject to Article 102 or the domestic equivalent of 102, but very few firms will be designated gatekeepers.
Okay, thank you.
But tell me I'm wrong, by all means.
No, who am I to say that? Anyone else?
No.
Thank you again, Professor. Okay, thank you. Just a question. Still regarding the SMS, can we say this test?
SMS.
SMS,
yeah.
yes.
Mm-hmm.
Well, because we have seen a lot of discussion about the DMA in Brazil. Recently, we had I don't know if you know this, but we have a bill in Congress, a bill of law. And we, in our law, in our bill, we don't have a specific the regulation or an article as we have in Europe about who should be considered as a gatekeeper, as you mentioned. So do you think the test could be a middle ground or something between here and Europe to achieve this, the same results, or to identify who should be prosecutor in Brazil or investigated?
Yeah, well, look, I don't know enough about the economy of Brazil, about the kind of platforms that are active here, about the extent to which the problem exists. I feel very hesitant about expressing a view as to what the right answer for Brazil is. Maybe by the time I've had my week here, I will have. Well, no, I mean, that's one of the great things about traveling around the world, because you get to understand local conditions. I have never believed in one size fits all. I think every culture, every country, every economy has to work out what is correct for it. I do like the idea conceptually of strategic market status, because I think it is intended to capture this idea that certain firms are in a position that they've already embedded themselves in such a commanding position that then it is, what shall I say, relatively easy to say, oh, there's a promising market that we could target, and there's another one, and there's another one. No doubt often using the big data that we have got from our position. And then you can, envelop it. It's like an octopus, with 8 tentacles, but conceivably 108 tentacles. And I think that if you're in that position, a bit of restraint imposed upon them is a good thing. It is a great thing to be a giant, but tyrannous to use the power of a tyrant. Shakespeare, Measure for Measure. I think it's a very nice phrase to bear in mind when it comes to this area. Paula?
Hi, Professor Whish. Thank you for all of your thoughts. I was actually listening, and I was wondering if you could give your thoughts on if the gatekeepers are not considered essential facilities, then how do you justify an ex-ante regime in which essentially the gatekeeper is someone that you have to pass through in order to be able to provide a service? Mm-hmm. So I was wondering if you could maybe give your thoughts on that, and then a little bit about why you disagree with Google's essential facilities position.
I think I'm correct, aren't I, in thinking that your bill does seem to see the problem as being those controlling an essential facility. Is that right? Sort of underpinning your bill is this idea that you are a kind of essential facility?
Yes and no, because it's very broadly defined. But you're correct that it's under. Yeah. Well, it's underlined there, exactly. But it's correct that the theory would be that. Yeah.
Because I've seen an English translation of it, and I see this expression "essential facility" in there. Well, look, the reason that I don't think that let's do it a different way. Let's think about why some law firms do want to turn these cases into essential facilities cases. I think it goes back to the Trinco judgment of the Supreme Court in the United States, where you had this telecommunications dispute. Was it Trinco against Verizon, wasn't it? And Trinco is complaining against Verizon in circumstances where this dispute has been looked at by the bespoke regulator, the Federal Communications Commission, which says, no, we're not interested in that. And then Trinco says, well, that's very frustrating. The regulator that's there to look after us isn't interested. Let's see if we can get somewhere using antitrust. And so they say, effectively, this is a refusal to deal by Verizon. And so let's try to sort of avoid the inactivity of the FCC by bringing a Section 2 claim. Well, that goes up to the Supreme Court that chucks the case out, not least by adopting a very, very, very narrow view of the US essential facilities doctrine, which that Supreme Court, which is very Chicago in its approach, I can understand how and why they did that. But quite apart from where they are philosophically in terms of antitrust generally, this is in circumstances where the bespoke regulator for the sector has said we see no problem, and where effectively Trinco is asking a US judge, because ultimately it's going to be a judge at district court level, to become the regulator of the access price of Trinco to the Verizon network. Well, I can absolutely see how a court in those circumstances is going to say this is really not a very good idea. And so how do you turn Section 2 off? By adopting a very narrow view of the essential facilities doctrine. So that's where US law is. And then I am a lawyer at Cleary Gottlieb in Brussels, representing Google in the Google shopping case. Well, obviously, my legal business is to defend dominant undertakings. And I'm going to try to persuade the powers that be in Europe, that's the Commission and then the courts, that the wisest system of competition law in the world is the US system. This is where the US system has got to with essential facilities. You in Europe really ought to do the sensible thing, which is to import into Article 102 thinking the thinking of US antitrust. And that is what is happening here. And it happened in Telia Sonera against the Swedish Competition Authority. It happened in Slovak Telecom and Deutsche Telekom against the Commission. Recent judgment was the Lithuanian railway system, Lietuvos against the Commission. And in each of these cases, Donco has argued this isn't margin squeeze or unfair terms and conditions. We're being accused of refusal to deal under essential facilities. And the Commission or the Swedish authority applied the wrong law. Now, in every one of those cases, the Court of Justice said, no, we disagree with you. There are refusals to deal, but there are other abuses as well. And the fact that it's not that abuse doesn't mean that it can't be another abuse. However, all of those are cases in regulated sectors where you've got very specific circumstances. Often there's a regulatory duty to deal anyway, and the facilities in question were created at state expense without private sector risk-taking and whatever. But now with Google Shopping, as far as I'm aware, Google has never been owned by the state. This is not a public utility from the 19th century that built the Lithuanian railway system. So I can see that Google Shopping is utterly, utterly different economically, historically, culturally from the US precedent. So the Court of Justice now is in a fantastic position where it has to make a decision. Is it going to accept the Trinco-type argument, or is it going to say, no, this is the EU and we're going to do things differently? Let's wait and see. Separate point, however, is I think the argument that these cases should all be treated as essential facilities cases, to my mind, that's just simply wrong on the law. Because if somebody controls an essential facility, and if you're applying competition law in its conventional way, you must be saying effectively that the market is the facility and that the owner of the facility has a monopoly. I mean, because that is what we're saying, that the essential facility is something that cannot be replicated, it cannot be duplicated. So in other words, I'm a monopoly over the transmission gas system of Ruritania. I've got 100% of the market, and by refusing access, I have abused a dominant position. Article 102 says it is illegal to abuse a dominant position. It doesn't say it's illegal to abuse a monopoly. The treaty could have said it's illegal to abuse a monopoly, in which case everything would be an essential facility case, more or less. But that's not what the treaty says. It's abusive to abuse a dominant position. United Brands had 43% of a banana market and was dominant and was found guilty of abuse. That's not to say that bananas are an essential facility. So I just think it's wrong in law to say that all of these cases should be run on the basis of essential facilities. And I don't know whether you've seen, the European Commission has just initiated a review of its guidance on Article 102 priorities, proposing new guidance on Article 102. And one of the very things it says is that in our guidance, we wrongly treated abuses like margin squeeze as an analogue of essential facilities. And we think in retrospect that that was wrong of us. So they've actually amended the guidance because they themselves are saying it was wrong ever to have thought of these cases in the sort of template of essential facilities thinking. So, I mean, I know what I'm saying is terribly controversial, and if anyone here works for Clery's or the Sao Paulo sibling of Clery's, we can have a fight afterwards. But that's what's going on here.
Can I move slightly to another subject as people think about other questions as well? That is, well, I think you make a strong case for why there are some limitations on applying competition law to digital platforms and why it may be reasonable to think on terms of ex ante regulation. I think that's an important issue. What I'd like to move is once you reach to that point where competition law is not fit for purpose in dealing with all issues, I think there are other questions that come up, right? So the first question would be, so what type of ex ante regulation is better to be issued, right? So you have like DMA-like regulation where you have lots of ex ante obligations in Article 5 and Article 6, and you're going to have all these complex enforcement going on, and have like somewhat more flexible approach like the German approach, right? The 19A approach that not lots of obligations are detailed ex ante, but in each case it's going to be detailed there. It's kind of the UK, the same approach. So I think one question would be, what's the best approach in your view? I mean, a more detailed approach like DMA, a more flexible approach like Germany or UK. And the other question would be, is it the case to actually have all these national legislations globally, when you think about this globally, like, and then have the US moving in, potentially Brazil moving in, and having like all these different ex ante settings, or should we see how it goes first in Europe, for instance, and learn with that, and then have other countries moving in?
Well, I mean, it's a great question, to which I could reply over about the next 20 minutes, but I will restrain myself. I mean, the first thing I would say is, and I find this very interesting in practice, that it is quite clear, is it not, that competition authorities do discuss these things one with another very frequently and very intimately. I said earlier, I do not believe in one size fits all, but I think there's huge benefits in competition authorities regularly, systematically meeting, exchanging ideas, etc. And I think that a system of regulation might fit Ruritania and be quite inappropriate for Arcadia. But that doesn't mean to say that Arcadia can't learn from Ruritania and vice versa. That's one thing to say. I also think that no one competition authority in the world can ever enforce, or one regulator can enforce to achieve the ideal outcome. However, I think it's quite clear that one authority can intervene And then a platform might change its behavior in response to what that authority has done, and might say, actually, you know, if we're going to change our business model for Ruritania, there might be a sense for changing it regionally or even globally, in which case an intervention by one authority might establish a kind of a global standard of behavior. And I mentioned in that slide a case that the CMA did about Google and its privacy sandbox. So this is about the third-party cookies that, you know, from which Google derives so much data, but so do other advertisers derive data through the same cookies. And then Google says it's going to remove the third-party cookies because that is a way of dealing with the privacy problems. So, well, thank you, Google, you're addressing the privacy problem. But in addressing the privacy problem, you're removing advertisers from access to that information. So actually, the suppression of the privacy problem actually creates a competition problem for the competitors of Google. So, as somebody once said to me, was it a case of Google privacy washing? We all know about greenwashing. Was this privacy washing? Now, Google said it will establish a sandbox for devising ways of getting rid of the third-party cookies, but without harming competitors. And we will do this in a sandbox, experiment with ideas, and these will be looked at by the CMA, by the Ofcom, your Anatel of the UK, by the Information Commissioner's Office, and only when a solution to the satisfaction of them and the market generally is devised will we actually change the cookies policy. And the CMA accepted commitments from Google, and Google said, having accepted these, having given these commitments, we will work to the right solution, and once we have found the right solution to the satisfaction of the CMA, we will change our business model globally. I thought, wow. So in that situation, you satisfy the CMA no doubt is talking to all the other authorities, and then that intervention by the CMA establishes a global standard of behavior by Google. So you do that, and then who's to say that the Japanese authority doesn't do something else, and the Australian does something else, and the European Commission does something else? That seems to me to be quite a smart kind of response, actually. Going back to, I mean, if you're asking me for advice to Brazil, I've already ducked that earlier in response to this, because I just don't know enough about it here. I did say that I don't like regulation for the sake of it. I think regulation needs to be very targeted and focused to achieve, you know, the optimal outcome. I have a feeling that the SMS approach is a bit more nuanced than the DMA gatekeeper approach.
Thank you. Any other questions?
Please.
Thank you, Professor. Well, you just said that you are concerned about exact regulation and it should be very accurate and targeted. Well, I've been thinking for a while the possibility that most of, or at least part of the concerns about platforms is the fact not only because they may have market power, which is related to price increase or reduction of innovation and all the damages that we know, but also related to economic power in a broader way and political problem in a broader way. And sometimes I get the impression that consider this ex-ante regulation design that you're discussing and seeing all around the world, they're really focused on, they are designed to control market power, but at the same time they may be too strong because they're also trying to target other kind of problems, and then the balance may not be so let's say efficient in this sense. So I'd like to hear some thoughts on that.
Well, no, absolutely, and it's a good question or observation. And of course, with my slides, I went through the early slides very quickly, but what one of those slides says, of course, there are loads of problems with these platforms, and it might be fake news, and it might be distribution of wealth, and it might be political power, and so on and so forth. And I think these are all issues for society at large to consider. My feeling as a humble competition lawyer is that as competition lawyers, we should recognize the strengths of competition law, but we should also recognize not the weaknesses, but we should recognize that competition law cannot solve all the problems in the world. And if the problem is that we think that this is going to be harmful to democracy through the spreading of fake news, or just that they're going to become so vastly wealthy that they've got more money stashed away in the Cayman Islands than the whole of Africa together, which I believe is the case actually, that's not for competition law. And I did look at your bill. Bruno sent it to me, and I noticed that there's quite a lot on the agenda with that bill. I prefer to start this by saying, in this big issue of platforms, there is a competition stroke market power bit of it, and I think I think there's a lot to be said for just focusing on that for us as a competition community, because that's difficult enough in itself. But to try to take on everything else at the same time, and not least, actually, you then have a regulator of some kind, whether it's whoever it is. How do you equip a regulator? Who do you choose to be on the regulatory board that has the skills, the knowledge, and the accountability to be responsible for all of that? You know, I have real concerns about that. So, and I also think that if you make this about, you know, the market power kind of issue, it's still going to be fantastically difficult. But at least you might have a set of human beings at that authority that can make good decisions. I think the more that you widen the scope of relevant criteria, the more difficult it becomes to make sensible decisions. So I think that absolutely addresses it. Yeah?
Thank you very much. I think we're coming to an end here. I had an agreement with Ricardo that he would also have some time for the meeting of Ibrac as well. But I think this has been a very thoughtful conversation, very thoughtful presentation as well, Professor Whish. So thank you very much for it. And I'd like just to give the floor to Bruno and Leonor for the last words here as well, and to Professor Whish before we can close our business here today.
No, just to say thank you again, Professor, for coming to our school again, and thank you again for Bruno. Just to say that women in antitrust should stay for a picture with Professor. Okay, thank you.
Thank you, Professor, for your brilliant words, as always. I have a lot of questions, but I'll save for later. And for those that arrived later, to remember that we still have places for the course. The professor will give 3 days. It's going to be from 7 to 10 today, tomorrow, and Wednesday. So whoever wishes to do that, please contact
First time
Ibrac.
ever I've heard that.
Thanks a lot.
Any final words, Professor Whish?
And having heard me, if you have signed up from Ibrac, I'm sure you can cancel. No, great pleasure to be here, and very interesting chat. Yeah.
Thank you very much. Thank you for being with us today and taking the time. I think this is a very, very tight trip. We've got a tight schedule, so having you here is really an honor and a pleasure. Thank you very much. And thank you all for being here and participating in this conversation.